Yes, we are in open session now. I want to make sure that the members of your family are fully aware that you are present here in The Hague and that you are being detained in our detention unit in Scheveningen.
Yes, they are fully aware of that, the members of my immediate family.
Is there any member of your family, immediate and not immediate, that you would like me to inform as regards your transfer here and your state of detention here in The Hague?
No, thank you. All those who need to know do know.
Is your embassy aware that you are here in The Hague and in a state of detention?
Yes. I arrived under the organization of the government of the Republika Serbia and Montenegro. It was their organization. They saw me off at the airport. There were 2 ministers escorting me in the aeroplane, and yesterday, the representative of the government of Serbia and Montenegro visited me in the detention center.
You need me to contact any member, any person from your embassy now or even later. Please do not hesitate to let me know. Okay.
Yes, thank you.
Now, Mr. Borovčanin, I am soon going to ask you to sit down, but before I do so, I would like to inform you that before our tribunal, every accused, and that also includes you, of course, from the moment you're taken into custody till the very last second of the proceedings, whenever those will come to an end, you enjoy a number of rights. Some of them are substantial rights, some of them are procedural rights. Our statute, which was approved by the Security Council of the United Nations, spells out these rights mainly in 2 articles, Articles 20 and Article 21. And I am now going to ask Madame Registrar to read out to you, and you will receive interpretation in the meantime, in their entirety, these 2 articles, and then I will ask you whether you are fully aware of the import of these rights. You may sit down.
You want me to state my views now?
Just sit down, and these 2 articles are going to be read out to you. Madam Registrar, could you please read out?
Your Honor. Article 20. Commencement and conduct of trial proceedings. 1. The trial chambers shall ensure that a trial is fair and expeditious, and that the proceedings are conducted in accordance with the rules of proceedings and evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 2. A person against whom an indictment has been confirmed shall present to an order or an arrest warrant of the International Tribunal be taken into custody, immediately informed of the charge against him and transferred to International Tribunal. 3. The trial chamber shall read the indictment, satisfy himself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set the date for trial. 4. The hearing shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of proceedings and evidence. Article 21. Rights of the accused. 1. All persons shall be equal before the international tribunal. 2. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to the Article 22 of the statute. 3. The accused shall be presumed innocent until proven guilty according to the provision of the present statute. 4. In the determination of any charge against the accused pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail in a language which he understands of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed if he does not have legal assistance of his rights, and to have legal assistance assigned to him, in any case where the interest of justice so require, and without payment by him in any such case if he does not have sufficient means to pay for it. E. To examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the international tribunal. D. Not to be compelled to testify against himself or to confess guilt.
I thank you, Madam Registrar. Mr. Borovčanin, could you please stand up again? You have heard Madam Registrar read out to you these two articles, which contain, as I explained earlier, your rights before this tribunal.
Yes, I have heard them and I have understood them.
Were you aware of their existence before coming here?
Yes.
Someone has, I take it, explained the import of these rights.
I have been following several trials going on here on television, and that was one of the pieces of information that I heard.
Mr. Borovčanin, have you been served with a copy of the indictment in your own language?
Yes.
Have you read it?
Yes.
Have you understood it?
Yes.
In other words, I take it that you are fully aware of the extent, the nature and extent of the charges that it contains and the 6 counts.
Yes, I have understood.
Now, you, as I explained earlier, you have a right to have the indictment read out in full here. But you also have a right, should you so wish, to waive that right. And in that case, the summary that I provided earlier on would suffice, even though in reality it's not even required by law. But for the time being it would suffice. So before I proceed any further, Mr. Borovčanin, would you like us to read out the indictment in full, or are you waiving this right?
Your Honor, I am waiving the right to having the indictment read out in full.
All right. And the next step basically is the most important part of today's proceedings. I will be asking you to enter a plea to each and every one of the 6 counts that are contained in the indictment. There are these options. You can decide and you can enter a plea on these counts today. And your plea can be one either of guilty or of not guilty. You can ask to defer till later. You're entering such a plea, in which case I can only give you 30 days. If either today or later on, but particularly later on, within and until these 30 days, you decide to remain silent, in other words, not to enter a plea at all, then I will enter a plea on your behalf, and that plea will be one of not guilty. Have you understood the 3 options?
Would the accused please be asked to speak into the microphone? Thank you. Yes, I have understood the options.
I have a request from the interpreters to ask you to raise your voice a little and try and speak into the microphone as best as you can. Are you prepared to enter a plea to the charges that are contained in the 6 counts of the indictment today, or would you like to defer entering such a plea till later?
Your Honor, I have understood the indictment. However, as the status of my defense counsel, whom I put forward, has still not been settled, I would like to defer entering a plea and not enter a plea today.
Every right to do that, and I am making it clear once more that you have 30 days maximum within which to do that. For that purpose, either I myself or another judge from my trial chamber, that's trial chamber 2, will preside over an additional initial appearance or a continuation of today's initial appearance. And unless you give us to understand that you are and you wish to enter the plea earlier, that additional initial appearance will be held probably the last day of this 30-day period. The counts that you are charged with, basically I made a reference to before, but for the benefit of the public I will just give just a little bit more detail. And the first count is a charge of complicity in genocide, as I explained earlier, which is punishable under Article 4.3e of the Statute of this Tribunal. And for this crime, you are charged both with individual criminal responsibility, pursuant to Article 7.1, and superior criminal responsibility under Article 7.3 of the statute. The second count relates to a charge of extermination, which is a crime against humanity, punishable under Article 5 of our statute. Even here, there is this dual criminal responsibility that is being attributed to you, that is responsibility under both subsection 1 and subsection 3 of Article 7. The third count contains a charge of murder, this being a crime against humanity, which is punishable as well under Article 5A of the Statute of this Tribunal, and even here the criminal responsibility that is being attributed to you in terms of the indictment is based both under subsection 1 and subsection 3 of Article 7. The fourth count is also a charge of murder, but this time it's being imputed to you as a violation of the laws and customs of war, which is also punishable under Article 3 of our statute. Again, Article 7.1 and 7.3 are being invoked as far as criminal responsibility is concerned. The fifth count is one of persecution, this being a crime against humanity, punishable under Article 5H of the Statute of this Tribunal, and again both subsections 1 and 3 of Article 7 of this statute are being invoked against you. And finally, the sixth count contains a charge of inhumane acts consisting in forcible transfer, this being a crime against humanity, punishable under Article 5I of the Statute of this Tribunal, and again Article 7.1 and Article 7.3 are being invoked. You may sit down. Thank you.
Thank you.
There are a few final things that I need to state. First of all, Mr. Borovčanin, I would like to draw your attention to Rule 63 of our Rules of Procedure and Evidence, and particularly to the first paragraph of this rule. This rule lays down that questioning by the prosecutor, and when I say the prosecutor, I don't mean just Madame Carla Del Ponte and no one else, but it could be any member of her office. Questioning by the prosecutor of an accused, including after the initial appearance, shall not proceed without the presence of counsel unless the accused has voluntarily and expressly agreed to proceed without counsel present. If the accused subsequently expresses a desire to have counsel, questioning shall thereupon cease and shall only resume when the accused's counsel is present. It's also important for you to note what is contained in the second paragraph of this Rule 63, namely that the questioning, including any waiver of the right to counsel that you may make, shall be audio recorded or video recorded in accordance with the procedure which is provided in another rule, which is Rule 43, and which I don't need to read out to you. And the prosecutor shall, at the beginning of the questioning, caution the accused in accordance with Rule 42A3. Rule 42A3 is an important rule that we have. And that is the prosecutor, if at any time you are questioned, interrogated, have a duty to caution you as to your right to remain silent, and that any statement or anything that you may say will be recorded and may be used in evidence. After this initial appearance, when I say after, I don't mean necessarily today, but within the next few days, I, as presiding judge of Trial Chamber 2, will appoint a pre-trial judge who will, first and foremost, schedule a status conference, which will be held within 120 days of the end of the initial appearance. This will be done in accordance or pursuant to Rule 65 bis A of the rules. This will only be the first of several status conferences to follow if you plead not guilty. And status conferences have two purposes. First of all, they are held in order to organize exchanges between the parties, prosecution and defense, on various matters, such as, for example, disclosure of documents and preparation for the trial itself, and also to facilitate the expeditious preparation for trial. In addition, and perhaps this is something that must not at all costs be underestimated, it will give the pretrial judge and yourself an opportunity to see each other in person. And the pretrial judge will ensure that you are being treated well in the detention unit, and will be ready to listen to any complaints or requests that you may have. This is why we hold status conferences periodically. When I say periodically, by regulation, status conferences are held not later than 120 days from each other. I signed an order on the 1st of April committing you to custody, where you will remain for the time being. But you may, in terms of Rule 65 of our Rules of Procedure and Evidence, file an application for provisional release. Filing an application for provisional release does not mean that you automatically will be granted provisional release. And it is very unlikely that provisional release be granted in the beginning or in the early stages of the proceedings. However, if you so choose, if you so want, you can file an application for provisional release anytime. Also, you can file it personally if necessary, if you so want, pending the assignment of counsel. In other words, the fact that you may not have counsel assigned to you between now and I don't know when should not be an impediment for the purposes of filing an application for provisional release if you come to the conclusion that you ought to file one. Of course, if you have counsel assigned to you, then that counsel will be in a position to assist you in this. Mr. McCloskey, I am going to repeat what I repeat in every initial appearance, and it's something that I am 100% sure that you are fully aware of. But I'm just reminding you that pursuant to Rule 66A, one of the rules, you need to make available to defense counsel in a language which the accused understands all the supporting material which accompanied the indictment when confirmation was sought, and this needs to be done within 30 days from the initial appearance of the accused. Obviously, the initial appearance does not end today. There is going to be an additional initial appearance, and the 30 days will start running from then. On your part, Mr. Borovčanin, I wish to draw your attention to Rule 72A of our Rules of Procedure and Evidence, which lays down or establishes a period of 30 days within which you are to file, if at all, any preliminary motions that you might have, and which that particular rule deals with. 30 days once from when you have received the supporting material in accordance with Rule 66 that I mentioned earlier. Again, this is not something that you need to worry about today or tomorrow, because there will be some time before the documents which the prosecution needs to disclose to your defense counsel are disclosed. Obviously, if there is a delay in the assignment of counsel, Mr. McCloskey and Mr. Borovčanin, there is, and you can take my word for it, that there will be an automatic delay in the 30-day period that applies to you and subsequently to him. I don't believe there is anything much more for me to say. I address you, Mr. McCloskey. Is there anything that you would like to, that you wish to raise at this point?
No, Your Honor.
Thank you. Mr. Borovčanin or Madame Rowan, both of you, is there any matter that either of you would like to raise at this stage?
No, thank you, Your Honor.
Mr. Borovčanin?
No, thank you, Your Honor.
You are standing up. Please, I have a final question to you. I want to make sure, because that is my duty, I want to make sure that from the moment you have been taken into the custody of this tribunal and during the transfer and following the transfer, you're being taken into custody and kept in detention at the detention unit, you have at all time been treated well.
Your Honor, the entire transfer up to the present moment, including accommodation at the detention unit, has been highly professional and proper. Thank you.
Thank you. That is important for me to establish. It is something that practically each and every person that has come here confirms, with a sole exception. I don't think there is anything else for me to add today. There will be an additional initial appearance in due course, and you will receive the proper notification later on. I thank you. The initial appearance stands adjourned.
Yes, we will.